Fantastic. So human rights and ethics. So before we get underway with the topic, a wee bit of background about myself. My name's Henry Flood, and I'm a senior privacy consultant here at Two Black Labs. I'll obviously be giving today's presentation. I haven't always worked in privacy. I actually started my career as a corporate lawyer, but I'd done a master's in human rights and data protection law while at Otago, so I was quite keen to move back into the privacy space, and fortunately I managed to get a job at the Ministry of Social Development, where I worked as a senior privacy advisor, and then moved across to Labs last year. So just as a bit of an overview of today, a bit of an agenda, we're going to set the scene with a hypothetical example, which will be tested on afterwards, of course. We're going to look at what human rights and ethics are, consider why they are important tools. We're going to discuss the role of human rights outside the courtroom. Then we're going to look at a couple of topics in a bit more detail. So predictive modelling, consent and contact tracing will get our attention, and then we're going to finish with a few practical recommendations for using a human rights and ethics approach in your organisation. Underway. So the trolley problem, we're going to do a hypothetical example here just to set the scene. So picture this: you're in charge of a technology project designing AI for self-driving cars. This is a reasonably well-discussed problem, but I want to start here to get you thinking, because it is a real issue that designers are having through today. So if the car turns a corner and sees two pedestrians on the road and it has to harm at least one of them when it swerves, what factors should be considered? Is the life of the driver more or less important than the life of the pedestrian? Should the car use information about the pedestrian's age and life expectancy when making the decision? What if there are 5 people in the car who can be saved if one pedestrian is harmed? If one pedestrian is older and lived a good life, should that individual be harmed ahead of a young, enthusiastic future ethicist? What if one pedestrian's in the process of committing a crime? The interesting thing about these questions is that people often respond quite intuitively with gut instinct, with empathy. So you get very different answers even within a similar group of people. Many intuitively feel that harming one healthy pedestrian to save 5 in the car is morally justified. But then it can be quite difficult to explain why they wouldn't kill one healthy individual in hospital to provide life-saving organ transplants to 5 other patients. Our intuitions might flip. There are really interesting cultural differences to responses too. So cultures which place a higher value on the elderly might be less willing to harm them in favour of saving the young. And some cultures are more or less willing to take a positive act to kill one person, even where taking no action kills 5. Should the car designers take these cultural differences into account when selling cars in different countries, or should there even be regional differences within a big country? Obviously, there aren't fixed answers to these questions, but it's important to think about how your organisation might go about solving these questions. What role will intuition play? What factors should be considered? Should there be a formal ethical and human rights framework in place ahead of time? Is it rule-based, harm-based, or both? I think the trolley problem's interesting, but it does feel far away. It feels a little dispassionate or theoretical, but there are examples much closer to home. The decisions we make, that our organisations make, can have huge impacts on individuals, on their rights. So your organisations will have discretion to disclose information to police in certain instances, or to take adverse actions against individuals, or individuals fitting a certain profile, or give special assistance to one cohort of clients but not another, or waive a debt or grant someone citizenship, keep someone in prison or under the care of the state. I'll talk to a few examples throughout the talk, but we need to be aware that ethics and human rights, they're not just lenses for futuristic designers. We should be considering them now in New Zealand on the problems you're facing. So what are human rights? They're the basic rights and freedoms that all people are entitled to. It's actually a really old concept, but it took prominence after World War II, particularly the UN Declaration of Human Rights in 1948. Did a lot to put them on the map. It was a response to sort of protect individuals with the atrocities of World War II so closely in recent memory. But then in New Zealand specifically, we have the Bill of Rights Act and the Human Rights Act as our key pieces of legislation, and they protect people from discrimination on certain grounds, ethnicity, sex, political opinion, religion, marital status, age, sexual orientation. They also protect people from unreasonable search and seizure. So, for example, the police can't just take a blood sample from you without reasonable justification. There's also an international aspect too, where we've signed up for a number of agreements, such as those to protect the interests of children. What is ethics? Ethics is the science of morality. It's about determining right and wrong. Like human rights, it's an incredibly old field, but by no means a settled one. So that makes ethics really difficult, but also, I think, very interesting. But why are we talking about them? Trust. Trust is the key idea here. So trust in so many institutions is low, particularly internationally. We have low trust in justice systems, in police departments, in large tech companies who have abused their market power, abused the large information asymmetries they have with consumers. Governments have been asking for too much information from their citizens. National health services have been selling identifiable health information to private companies. Police departments have been using predictive analytics to determine where crime might occur, and of course have profiled certain people in the process. And these invasions of privacy, these harms to individuals, they aren't impacting everyone evenly. Particular groups are being made worse off, significantly worse off in some contexts. And so our institutions, both private and public, need to earn back, or actually earn for the first time, the trust of the individuals whose personal information they hold. And I think taking a strong human rights and ethics analysis is crucial to that outcome. It's part of the solution. Isn't human rights about litigation? Partly, but not today. So today, we're not going to focus on human rights as a lawyer would from a litigation perspective. We're going to consider them as a tool to be used by non-lawyers when designing and implementing projects. So human rights can be incredibly powerful in the courtroom, but we're not focusing on that today. We're looking at them as a non-lawyer would during internal processes within your organisations. There's a few reasons for this. First, we're not all lawyers. I'm a recovering lawyer myself. Second, human rights can be used in litigation to work against individuals. It's not just a protection. So, for example, a private company can claim to be exercising its right to freedom of speech against an individual's right to privacy, for example. And I watched with slight despair seeing a CBS interview with Clearview AI's founder and CEO, and he said that his firm was protected by a First Amendment right to scrape all the information from public that they have to create their database. Third, I don't think human rights law in New Zealand protects privacy in court and litigation as well as it could. Often actions are brought as freedom from search and seizure, which is great at stopping that policeman from arresting you and collecting a blood sample unfairly, but not at protecting you from secondary use of that blood sample for profiling purposes or from further disclosure to others of that information. Our courts are also set up to protect sole individuals who have suffered a clear harm, but many discrimination harms, such as sexist hiring practices, are harder to prove for an individual, and they only become clear when you start to aggregate the harms to individuals, which compromise the group. So any one individual might not have much of an incentive to bring an action. So I think it's better for a staff member to consider human rights implications during the project design phase, rather than having an affected individual have to figure out about being discriminated against and then take something to court after the fact. Finally, litigation erodes trust. It's expensive and it should be seen as a last resort process, particularly in New Zealand, but overseas as well. There's really long delays too. So in New Zealand, the backlog of the Human Rights Review Tribunal means you can wait for up to 2 years to be heard and then another 3 years for a decision. So yes, human rights litigation has a powerful history, it carries weight and it can help to change norms, but it's an infrequent solution. The value of human rights today is looking at it as an internal tool before harm happens, not after the fact. But I will say that flagging litigation risk, particularly discrimination, can be a good way to get buy-in internally to change behaviours and processes. Okay, why are we talking about this now though? Well, there's a few reasons. There are some interesting social drivers. So I think we're seeing people's expectations about how their data will be handled change. So consumers are demanding more, citizens are demanding more. In recent years, there's been a strong surge in the visibility of privacy, GDPR, New Privacy Act. These things are helping. And so I think it's natural that we're seeing human rights and ethical considerations for personal information increase as well. We're also seeing a rise in environmental, social and governance metrics, including ethics, come into definitions of shareholder value for businesses. So there are big shifts happening in the financial services industry. So investors like Blackstone and JP Morgan are leading the way internationally, but closer to home in New Zealand, banks make some good strides, and the New Zealand Super Fund is a market leader for considering ethics in investment. So there's a profile there that's building. There's also a huge technology driver here. So obviously new technology is allowing more information to be collected and for that information to be processed in new creative ways at greater speed. I hope you managed to catch last week's presentation on AI, where we went through a number of the interesting new developments. But the value of a lot of that new information technology depends on people being willing to provide their information. There has to be trust. So if people don't trust a company with their data, they'll go elsewhere if they can. And if people don't trust a government, they won't use the services or they'll elect someone else. So there's a lot at stake. Take an optional coronavirus application as an example. If people don't trust the vendor providing it or the government rolling it out, there's going to be low uptake of people using it. And if it is in fact really useful, then low uptake means we're going to miss out on those benefits. I think we're also talking about human rights and ethics today because I think compliance isn't good enough. It's only a start. We're starting to see organizations distinguish themselves, market themselves as trustworthy custodians of information. I think Apple obviously is a well-known example of this, and not to say that they're acting ethically across the board in terms of their supply chain or hiring practices, but certainly they're positioning themselves as ethical custodians of personal information. And I think that ultimately buy-in from users doesn't end with compliance with the rules. You should be empowering them, protecting their interests, regardless of what the law says. So compliance will minimize your risk of being fined or successfully taken to court, but there's plenty of compliant but unethical behaviour you can engage in, which will lose your customers' trust. The law in New Zealand might only give living individuals the right to privacy, but moving beyond compliance, consider what is the right way to treat the personal information of those who passed, and how might that be different for different groups of individuals. I think one of my favourite examples, the often cited Target example from the US, I think it's a really interesting case study looking at that different lens of compliance versus ethics. So what happened was a father went quite angrily down to Target after seeing that his daughter, his teenage daughter, had been specifically advertised to with some baby-themed promotional material, which was completely inappropriate, he said, and Target apologized to him. So Target had analysed the daughter's spending habits and inferred that she might be pregnant based on those the purchases she'd been making, and so they sent her the promotional material. They had a data analytics specialist who had figured out that there might be an association there. She was actually pregnant and hadn't told her father yet, so the promotional material forced her hand. And it might have been legally compliant to use her information in that way to target her with products that that they thought she might be interested in. It might have been legally compliant to send that promotional material to her stated address, even if Target knew she lived with her parents. But was it ethical? Was it appropriate to make that inference in the first place? Was it appropriate to act on it? I'll leave that with you, but I think to build and maintain real trust with people whose information you have to move beyond compliance. Okay, so we're going to look at three interesting areas now where I think human rights and ethics are particularly relevant, and then we'll move on to some more general and pragmatic recommendations to take back to your organisations. So the three topics we're going to look at are predictive modelling, COVID-19 tracing applications, and consent. So predictive modelling using statistics to predict outcomes. I think ethics and human rights considerations, particularly discrimination concerns, are having a huge impact, or having a positive impact, I should say, on predictive modelling, perhaps not as big an impact as they should. And the issue is that inaccuracies in predictive models are bad, but inaccuracies which have disparate impacts on different groups are particularly bad. So if you caught last week's presentation, I mentioned Amazon's secret AI recruiting tool, which gave job applicants ratings out of 5 based on their CVs. Unfortunately, Amazon's models were trained on historic Amazon application data, and for software development jobs and other more technical posts, most of the previous applications, and certainly the successful applications, came from men. And what that meant is that looking forward, Amazon's system taught itself that male candidates were preferable, and it penalised CVs that included the word woman in it, so woman's chess club captain, and it also downgraded graduates of women's only colleges. So Amazon edited the programs to make them more neutral to those particular terms, but they still weren't confident that other ways of sorting candidates weren't discriminatory or unethical, so it pulled the technology. But the flip side to this is that decisions made by humans, including hiring decisions, have been riddled with bias for generations. So people lie about the factors that they considered, or they may not understand the factors that influenced their thinking. It can be quite easy to hide behind one particular factor and not admit or even realize that other less appropriate factors had a role. So you could tell yourself that you liked the way a particular candidate answered a question, or latch on to something about their work history to decide that they should get a job, get a loan, get extra assistance, but it could well be other factors shaping your decision. So if computers could accurately predict the right applicants, then you could have a fairer system. And I spoke about this last week, and that it's easy, very easy, I think, to point out examples of predictive modelling done poorly. Weapons of Math Destruction and Automating Inequality were two books that came up. But I think we do need to be optimistic here and see the benefits of when it's done well, particularly against the current status quo. We need to hold designers and decision makers to account, absolutely, but I think we need to see the value as well. So some key points for predictive modelling: be clear about the type of data which is feeding the model, where that data comes from, you have to think carefully about the quality and the limits of the data that's used to train the models. Has it aged? Where are the inaccuracies? What's missing? How is it incomplete? What bias is in there before you begin? I think it's really important to have a range of views in the room in the design process. So this is such a cross-functional area: data scientists, programmers, ethicists, lawyers, statisticians, privacy consultants, obviously, users, consumers, advocates, different cultural perspectives. So crucial to have that broad range of views contributing. Layered privacy notices, as we so often say, are great. Short explanation up front for most, and then further detail in behind for those that want that extra detail. You have to be really open about the limits of your models too. On that front, I'd flag there's a risk there that if you're using a vendor who ruthlessly hides their model from scrutiny, that can be an issue, and you should absolutely be considering that during the procurement phase. Testing and retesting for discriminatory effects, absolutely crucial. And then again, as we touched on last week, don't be afraid to abandon the project. Manage expectations up front that this is a difficult area. And if you get yourself in a situation where lots of resources have been spent, but the model is producing bad outcomes, it's discriminating, there are ethical concerns, you might need to stop. It's not always possible to try and retrain a predictive model. COVID-19 tracing applications. I'm seeing a lot of talk about this internationally, obviously in New Zealand as well, so I couldn't help but put it in today's talk. So we're going to consider an application that goes slightly further than our one in New Zealand. This app for today, let's say it relies on Bluetooth and it keeps track of other phones that have their application and Bluetooth applicated. And so if someone finds out that they have COVID-19, they make that notification in the app, and then all the other phones that they came in close contact with get a notification that they need to get tested too. So taking a human rights and ethics lens, how might this application affect different groups of people? Because contact tracing is an area that we're told needs to be done well. It's difficult to do well. It feels like this is a wonderful solution, and there's almost a feeling of this could be the cure-all. But let's dive into it. How could it affect different groups? Well, in the UK, for example, more than 20% of adults don't have a smartphone. So what happens if the app becomes a tool for determining who can return to work or who can use public transport? How is that going to impact on different groups? Looking into that 20% a bit more closely, are they privacy conscious smartphone skeptics? Maybe. Or are they largely older and poorer individuals who might have other health concerns? That's an important question to consider up front. Studies suggest we have at least 10 close contacts a day with direct touch or a really close one-on-one conversation, yet without social distancing, the average individual with COVID-19 appears to affect somewhere between 2 and 3 people over the entire course of the disease. So that means that most exposures that are going to be flagged by the apps probably won't have led to an actual infection. So many users might be instructed to get tested or to self-quarantine, even though they don't have COVID-19. And there's an element there of safety first, but think about how that burden might affect different groups. So how might that affect those who can easily work from home and have a larger house that they can have a bedroom of at the end of? How might it affect those who work in a factory and live in cramped accommodation? So these issues need to be flagged up front. It's not enough to note that there will be some inaccuracies with any solution. You need to dive into how those inaccuracies will impact different groups, and then think about how those harms can be avoided or mitigated. that act could also be deliberately misused in really interesting ways, which I think should also be considered. And we touched briefly last week on this, where I highlighted that someone could falsely claim to be infected waiting in line to vote, say, in an area with a known political sway. But there are other unethical commercial uses too. I could go and make false claims at the regulator's office or at a competitor's office, particularly if the app is anonymous. Consent. So consent's been a fundamental aspect of ethics for centuries. It can permit otherwise impermissible actions. So sexual relations, borrowing a bike, and surgery can be changed to sexual assault, theft, and grievous bodily harm. The standard for consent is that it should be freely given, informed, and specific, but the issue is there can be subtle layers of coercion, a lack of understanding, there can be ambiguity, and all those factors weaken consent or actually render it invalid. The problem is when it comes to consent about how personal information is handled, we seem to have struck an incredibly low bar. The obligations on the individual to read all the terms and conditions, form a view on the risks, and then decide whether to consent. And often you have to consent to everything to get the one thing that you want. There's a well-known Carnegie Mellon study which showed the average internet user needs 76 work days a year to read all the privacy policies that they encounter. How could you possibly give informed consent? And so this is where I think taking a human rights and ethics view of consent is really useful, because the bar shouldn't be what can we get away with legally, or let's just not be the worst offenders so we avoid the regulator. You should be asking, how can we be as transparent as possible? How can we make sure any consent is properly informed and specific? How can we remove or mitigate any coercion that might exist? And we often miss slight coercive environment, say an employee feeling obligated to consent to their employer doing something. I think more organisations are recognising an ethical obligation here to be transparent and not hide behind obscure legalese, but there's such a long way to go. And in my role, I tragically actually had to read the privacy terms and conditions, and many are awful. But there are some organisations out there distinguishing themselves on how transparent they are with their customers and the quality of consent that they receive, which I think is great. Taking a human rights and non-discrimination lens to consent is also, I think, really useful. So dive into how might different groups face different challenges in giving consent. So we're seeing more notices available as audio for those who can't read well, or in different languages to account for different English skills. We're seeing more of those layered privacy notices that I mentioned before, with the simple explanation up front and more detail and behind to account for individuals of different knowledge, interest, time, age and ability. But something to watch out for, again, like with the COVID tracing app, is what about those that aren't digital, that don't have a smartphone or don't like using it? They still need to get really good information if they're going to be giving meaningful consent in a given context. And then, as I quite like to talk about when I look at the future of how this might change, I think, could we have an AI that was trained with our consent preferences, that moved through the digital space and flagged some terms and conditions for us to consent to, but it knew that we'd consent to some outright, so it does that, and then it rejects some outright. And as I said last week, I think that's an interesting idea, but I wouldn't want a solution like that to think that organisations could just persist with the long legalese, the obscure consent process that we see so often today. Okay, so now we're going to go on to some general recommendations, and I hope some practical recommendations for your organisation. communicate the value, get the buy-in. You can't use you can't use human rights and ethics to improve information handling in your organization just by yourself. It's difficult. You need buy-in, preferably from the leadership team. And so I think it's important to be really strategic about how you go about that and how you position that uplift. And so some leaders take a real customer perspective. So make sure to emphasize that building of trust that comes from transparency and treating data ethically and in a non-discriminatory fashion. Other leaders might want to avoid bad press, so you can emphasize the importance of testing predictive models for bias ahead of release, or the bad press that can come from having customers consent to things they didn't expect and then are actually really uncomfortable with. Some leaders take a compliance perspective, we know that. And so you can emphasize the litigation risk for discrimination, or perhaps how being transparent and treating data fairly might reduce exposure to certain areas of consumer protection law. Complying with the new Privacy Act, I think, is a good lever here that can get things moving as well. So getting buy-in absolutely depends on the culture that you're starting with and where you want to go. But you need resources and you need buy-in if you want to make that systemic change. Develop a framework, borrow a framework. The human rights and ethics framework we use can shape the risks we consider, and certainly then the recommendations that we make. So do your research here on what will work for your organisation, and then keep it updated. But you certainly don't have to go alone here. So the Ministry of Social Development have done some really interesting initial work with their privacy, human rights and ethics framework, and they're certainly open to sharing and having a cross-agency approach there. The Social Wellbeing Agency, formerly the Social Investment Agency, has developed data protection and use policy, DPUP. We have a multi-data sovereignty network that have published guidelines. There's a data ethics advisory group led by Statistics New Zealand. Microsoft have released their own responsible AI principles. There is actually a lot out there in the market, and there isn't a huge agreement. Obviously, this is a difficult area, but there's certainly some frameworks that you can build from and personalize for your organization. But it doesn't have to be a formal framework or a huge change. So for some organizations, for some projects, just adding an open-ended question and a privacy impact assessment could be a good step in the right direction. So you can ask, will some groups be made worse off as a result of this initiative? And then how is this justified? Put in good guidance and good examples, but just having questions like that in there, I think, can be really good for raising awareness and raising maturity as well. In other contexts, though, you might want to have a really formal process. So certainly there are processes for engaging external research ethics committees in certain situations, and I think that's a really good thing, obviously. Perhaps at your organisation, it might just be starting with a single project, looking at your transparency, how transparent you are with your customers or your clients, or perhaps it's a review of the consent you're getting across your organisation. You certainly have a huge range of options here. Develop skills that include a wide range of views. I think it's interesting that human rights and ethics feels like a very specialised area. We must need a lawyer, a philosopher, an ethicist. But you don't. Consider how juries are used. We gather 12 people from all walks of life with a broad range of skills and experiences, and we get them together to test evidence and determine what's reasonable, what's not. The problem is so often the policy settings we set, the technology we design, the decisions we make are controlled by a really narrow range of views. Often those of lawyers and programmers, normally male, middle-aged, and white. But what is reasonable, what is fair, what is ethical, those are questions everyone has something to contribute to if they're asked. So if you can put those questions to a range of people, it shouldn't be just the lawyer who drafts the consent form. Someone on the front line probably has something to say about where customers seem to be getting stuck or what questions they ask. Different communities should be consulted because the use of personal information in one community might not be appropriate in another. Someone with limited sight or hearing issues, they'll have something to contribute about what their needs are. This is obviously standard advice, but I think absolutely worth repeating. Focus on the high risk areas. So, as we spoke about before, predictive models are certainly a high risk area, but I think too potentially a lot of value there, a high benefit area as well potentially. But have a look. Is your organisation using predictive models? Perhaps you have a model which determines which customers are offered which products, or who gets that extra support. We'll dive into it. How are those models reviewed, if at all? What level of inaccuracy is permitted, and is the inaccuracy worse for certain groups of individuals? Are people missing out on a benefit, or are they actually incurring some direct harm because of that inaccuracy? Really important questions, and certainly an area that should be getting attention in your organisations. Consent, as we spoke about before, particularly with consent, consider whether you're working with vulnerable groups and whether you have a special process there. So do you have a process for getting the consent of children? When would you rely on parents' consent, or when would you allow the child to consent? And what would you do if they want different things, but the child's 16, 15, 14? Depends on the context, but interesting question. Do you have a process for getting the consent of seniors? What about a special process for act on behalf situations? Perhaps there's an adult child who acts on behalf of their aging parent. What information do you rely on to establish that relationship, and what flags would you look out for to reduce the risk of elder abuse? I think a big question for consent, and it's one that doesn't get asked often enough, is how fresh is it? How recent is it? Are you getting consent once and then forgetting about it? Every 2 years isn't a bad guide for keeping consent fresh, but you should be checking in more regularly than that if it's sensitive or higher risk. I think complaints and concerns are really important too. So ensure you've got appropriate channels for whistleblowing, for the higher levels of unconscionable conduct. That's a deterrent, as well as allowing it to be more discoverable. But I think you want something more informal too, where people can raise concerns or questions about whether they think some practices might be slightly discriminatory or unethical, and they don't want to go through a formal complaints process. So that might that could be anyone in your organisation. Doesn't have to be the privacy officer, but that absolutely could be whether people feel they can go and flag issues around certain business processes or how personal information is being handled, how decisions are being made. I think it really helps to have those trusted relationships within your organisation to allow you to then build trusted relationships outside of it. At the end of the day, I think trust is really the key takeaway. It's so important in privacy, and I think that human rights and ethics are such important tools to to help develop it, to nurture it. And it's so important internationally. We're seeing the effects of low trust in our institutions. And so, I really do believe that taking a strong ethics and human rights lens in internal processes is a good step, but absolutely only a small part of the solution. So look, a big thank you to you all from the team here at Two Back Labs. Thank you for taking time out during these very interesting times that we're in to either come along to our initial lunch and learn sessions, which were in person, or obviously to these online coaching on the couch. It's been great to see such an interest in what we think are incredibly interesting topics. I think we've had over 1,500 sessions of attendance, so we'll absolutely be continuing these types of sessions again. And if you've got any feedback on how we could improve the experience for you, or in particular if you've got any topics that you'd like to see covered, please do get in touch. The privacy bill is nearly through, so likely to be in effect this year. Absolutely watch this space, but we do need to see it signed, sealed and delivered before we confirm that it will be in effect this year. We have a free readiness assessment on our website if you're interested in visiting that and getting an initial view, and as always, we're happy to help with any concerns you have.